Yes, sir.
Good morning, Your Honor. May it please the court, Ben Chu for plaintiff Johnny Depp. Mr. Depp hereby moves to strike defendant Amber Heard's counterclaims because Ms. Heard has not proven by clear and convincing evidence that Mr. Waldman made the 3 allegedly defamatory statements with actual malice.
Right, but clear and convincing is not my motion to strike standard.
Understood, Your Honor.
Okay.
And we have cited the standard in our brief.
Thank you.
Moreover, Your Honor, the court should also strike defendant's claim for immunity and attorney's fees based on Virginia's anti-SLAPP statute, as she is not entitled to immunity under the statute. Because we know that the court has carefully reviewed our motion papers, I will just hit some of the salient points.
Thank you, sir.
Thank you, Your Honor. I would mention, however, Your Honor, that because this is not included in our brief, that there is no record evidence whatsoever that Mr. Depp even saw any of the 3 statements that Mr. Waldman made prior to being served with the counterclaims in this action, which we believe is relevant to many of the legal standards. And as Your Honor is aware, Ms. Heard had signaled for the past week that she was planning to call Mr. Depp in her case in chief, and it was our anticipation that she would try to fill what we believe is a gaping hole with respect to the elements of her proof. Again, there's no record evidence whatsoever that Mr. Depp ever saw any of the 3 statements about which Ms. Heard is purportedly suing him for $100 million. As Your Honor is aware, the elements of defamation are as follows. 1, publication of 2, an actionable statement with 3, the requisite intent. See Tharp versus Sanders, 285 Virginia 476 at 2013. The requisite intent for defamation against a public figure is actual malice. That is, the statement must be made with knowledge that it was false or with reckless disregard of whether it was false or not. See Sanders v. Harris, 213 Virginia 369 at 372, a 1972 case. See also Jackson v. Hartig, 274 Virginia at 2019. Reckless disregard, as Your Honor is aware, quote, is not measured by whether a reasonably prudent person would have published or would have investigated before publishing, ellipsis. There must be sufficient evidence to permit the conclusion that the defendant, in fact, entertained serious doubts as to the truth of his publication, unquote. St. Amant versus Thompson, 390 U.S. Supreme Court, 727 at 731. Your Honor, the evidence shows that Ms. Heard cannot prevail on her claim because she cannot and did not establish that Mr. Waldman made the statements with actual malice. Mr. Waldman testified that he conducted extensive investigation and reasonably believed that the 3 statements he made were true. Ms. Heard presented nothing to contradict that undisputed fact. Ms. Heard has no evidence of direct liability because obviously, Your Honor, we need to talk about direct and vicarious liability, but it bears noting that she has no evidence of direct liability and cannot prove actual malice by Mr. Waldman when making the 3 statements at issue. It is undisputed that Mr. Depp did not make any of the 3 statements at issue in Ms. Heard's counterclaim. Moreover, in order for Mr. Depp to be liable for the conduct of one of his attorneys, there must be some showing that he directed, participated, or otherwise authorized Mr. Waldman to make the statements at issue. There is no such evidence on the record that Mr. Depp directed or otherwise authorized Mr. Waldman to make the 3 allegedly defamatory statements at issue in the counterclaims. Indeed, there is no evidence of any communication or coordination between Mr. Depp and Mr. Waldman regarding the counterclaim statements or anything else. For this reason as well, Your Honor, Ms. Heard cannot meet her burden of proving that Mr. Waldman was acting within the scope of his employment as our agency on behalf of Mr. Depp. Again, it bears noting that there's no evidence that Mr. Depp even saw the statements by Mr. Waldman until he was sued, served with the counterclaims well into this case. It was more than a year after Mr. Depp filed his complaint, and Ms. Heard lost a series of motions to dismiss that she finally asserted her counterclaims, most of which have already been dismissed by opinion letter of this court. Whereas here there is no evidence of direct liability, Ms. Heard must rely on a theory of vicarious liability to hold Mr. Depp liable for the actions or statements, rather, of his purported agent, Mr. Waldman. Vicarious liability is by definition, quote, liability for the tort of another person, unquote. So to hold Mr. Depp liable for Mr. Waldman's statements, Ms. Heard must establish that Mr. Waldman himself committed all the elements of defamation. I know the court's familiar with this, so I'll try to run through it quickly. See Parker versus Carillon Clinic, 296 Virginia 319 at 332, a 2018 case. Quote, vicarious liability is liability for the tort of another person. It necessarily follows that a claimant cannot make out a case for vicarious liability against an employer without first proving that the employee committed a tort within the scope of his employment. See also Roughton Pontiac Corp. Versus Alston, 236 Virginia 152 at page 156. Which standard Ms. Heard has not met? And Your Honor, we cite a string citation to cases from other jurisdictions, which we obviously are not binding on the court, but we believe are influential. We presented those to the court for its review. It is Ms. Heard's burden to prove by clear and convincing evidence, or ultimately, to prove actual malice by Mr. Waldman, not Mr. Depp. And while it is well-settled law in Virginia, as Your Honor has pointed out last week, that an agent's knowledge can be imputed to a principal, and this is the Allen Realty Corp. Versus Holbert case, 227 Virginia 441 at 446. Ms. Heard's counsel cannot cite any case law stating that a principal's knowledge is imputed to an agent. In other words, Mr. Waldman must have made the statements knowing that they were false or with reckless disregard as to whether they were false. And Mr. Depp's knowledge cannot be imputed to him. There is no evidence in the record that Mr. Waldman knew the counterclaim statements were false. Indeed, Mr. Waldman did not even know Mr. Depp or Ms. Heard at the time of any of the alleged incidents at issue, and thus had no personal knowledge of what transpired. And this is reflected in the trial transcript that Mr. Waldman met Mr. Depp first in October of 2016, long after the fact. Nor is there any evidence in the record that Mr. Waldman subjectively entertained any serious doubts about the falsity of the counterclaim statements. Quite the opposite. The evidence shows, and it's unrebutted, that Mr. Waldman had very reasonable grounds to believe, and he did believe, and will to his dying day, that Ms. Heard's claim of abuse were patently false. Mr. Waldman testified at length about 29 witnesses he believed disproved Ms. Heard's false claims of abuse. See the transcript at page 6008 through 6012, and I won't run through all of that. But his testimony that two trained police officers, Officer Science and Haddon, were called to the penthouse on May 21, 2016, and saw no signs of injury on Ms. Heard's face, as well as, quote, Ms. Heard's own witnesses who have testified in various forums at various times that there were no injuries to her face whatsoever between May 21st and May 27th, 2016, when she walked in to court with her publicist, her lawyer, her former best friend who no longer speaks with her, for a no-notice ex parte TRO. Some of the witnesses whom Mr. Waldman has cited, they include Laura Devanere, Melanie Iglesias, who, as Your Honor recalls, was Ms. Heard's makeup artist, who decided to end any professional or personal association with Ms. Heard. Samantha McMillan, Hilda Vargas, Isaac Baruch, Trinity Esparza, Cornelius Harrell, Alejandro Romero, and Brandon Patterson, just to name a few. No reasonable jury could find that Mr. Waldman acted with actual malice in making the allegedly defamatory statements. He was not present for the alleged incidents. He has no personal knowledge of any of the alleged incidents. What Mr. Waldman knows is a product of the legal work he did, the sleuthing he did on behalf of Mr. Depp. Ms. Heard cannot possibly show that Mr. Waldman acted with actual malice, and her defamation claim must fail. 2, Mr. Waldman is an independent contractor, not an employee. It is axiomatic, Your Honor, that a person who hires an independent contractor is not liable for the independent contractor's actions. See Sanchez versus Medicorp Health System, 270 Virginia, 299 at 344. An independent contractor is a person who is engaged to produce a specific result, but who is not subject to the control of the employer principal as to the way to bring about that result. See Atkinson versus Sachno, 261 Virginia, 378 at 284. That's a 2001 case. An outside lawyer retained by a client in connection with litigation is an independent contractor. See King versus Dalton, 895 F. Sup. 831, Eastern District of Virginia, 1995.
Benjamin Chu arguing in front of the judge to throw out Amber's case, saying there's nothing there. It's procedural. We'll see what happens. We'll get a break in here, pick it up when we return. Stay with us.
The app where your hard work pays off.
Welcome back to Court TV Live. If you're just joining us, Amber Heard's team has rested its case in chief. They did it outside the presence of the jury. And that immediately triggered a motion from Johnny Depp's team. And Benjamin Chu is arguing that motion in front of the judge, asking that Amber Heard's counterclaim be thrown out. Let's go back in where we left off.
Where Judge Ellis, a legendary jurist known by all Virginia practitioners, held that, quote, a law firm attorney working with a client is nonetheless an independent contractor and is not an employee of the client corporation. In that case, the employer was a corporation, but the same logic applies when it's an individual like Mr. Depp. That was Mr. Waldman's role. Indeed, clients hire lawyers to obtain specific results or to try to obtain specific results, but they do not control the means by which the results are accomplished. Lawyers, as Your Honor has reminded us, are subject to professional obligations to exercise independent professional judgment. We are not at the whim of our clients as much as we want to serve them. See Virginia State Bar Professional Guidelines, Rule 1:2 and 2.1. And just to quote 2.1, in representing a client, a lawyer shall exercise independent professional judgment, unquote. Mr. Waldman is, as a matter of law, an independent contractor, and Mr. Depp cannot be held responsible for any alleged tort by his attorney, particularly for statements about which he was unaware until he was sued for them. Mr. Waldman testified, and it's unrebutted, that he has his own law firm. He's not an employee of Mr. Depp. Mr. Depp or none of his loan-out companies have issued him a W-2, and Mr. Waldman provides legal services to clients other than and in addition to Mr. Depp, and that's found at the transcript, page 6020 through 21. All of that is unrebutted by Ms. Heard. Mr. Waldman's statements, the third reason for which we respectfully submit the counterclaim should be stricken, is that Mr. Waldman's statements were protected opinion. And I won't run through all of that, but very briefly, taken in their proper context, the counterclaim statements are non-actionable expressions of opinion entitled to protection under the First Amendment. See Gertz versus Robert Welchink, 418 U.S. 323 at 339. That's a 1974 case from the United States Supreme Court. See also Shacker v. Bufault, a Virginia Supreme Court case found at 290 Virginia 83, a 2015 case, noting that where, quote, all sides of the issue, as well as the rationale for the speaker's view were exposed, the assertion of deceit reasonably could be understood only as the speaker's personal conclusion, unquote, and finding an accusation of deceit to be opinion. In context, Your Honor, any reporter or any reasonable reader would understand and expect a lawyer associated with Mr. Depp, as Mr. Waldman was, to challenge Ms. Heard's version of the inherently controversial events of the parties' marriage. Just as Ms. Heard's lawyers were quoted challenging Mr. Depp, and Your Honor will remember the context of these quotes that were in a British tabloid where Mr. Waldman's statements were buried well into article in which both points of view were clearly expressed. And Mr. Waldman was clearly identified not as an independent expert on the U.S. Constitution, but as one of Mr. Depp's attorneys. C. Chavez, 230 Virginia 112 at page 119, quote, the most unsophisticated recipient of such a claim, i.e. any reader of the British tabloid, made by a competitor against another could only regard it as a relative statement of opinion grounded upon the speaker's obvious bias, unquote. Mr. Waldman has never did anything to hide his support and belief in Mr. Depp. Finally, Your Honor, and for the rest, ultimately, Mr. Waldman's statements reflect the existence of two competing narratives and are merely his subjective view about events that he never claims to have witnessed, and there was no doubt about that. Turning to the second part of the argument, which will be more abridged, Ms. Heard is not entitled to anti-SLAPP immunity. As a threshold matter, Virginia Code Section 8.01-223.2, which is, as Your Honor well knows, is the Virginia anti-SLAPP statute amended most recently in 2019, provides in relevant part, quote, the immunity provided by this section shall not apply to any statements made with actual or constructive knowledge that they are false or with reckless disregard for whether they are false. Here, in addition to Mr. Depp's testimony, several witnesses have testified that A, they never witnessed Mr. Depp abuse Ms. Heard, and B, that they observed Ms. Heard without any injuries, marks, bruising, swelling, etc., during periods when Ms. Heard claimed to have injuries, marks, bruises, etc. Such witnesses include, but are not limited to, Isaac Baruch, Kate James, Dr. David Kipper, Nurse Debbie Lloyd, Officer Sines and Haddon, Officer William Gatlin, and former U.S. Marine Starling Jenkins. Ms. Heard's request for anti-SLAPP immunity should be stricken, and even if there were disputed facts as to that, the anti-SLAPP immunity does not apply because the defamatory implication of Ms. Heard's statements are not solely relating to a matter of public concern, as is required under the statute. As has become quite clear, Your Honor, Mr. Depp is not suing about any of the public policy commentary made by the ACLU when it drafted the op-ed, and Ms. Heard put her name to it. what he is suing about here are the 3 statements that were directed at him. He has no issue with women's rights. He supports women's rights. In fact, he was the one, Your Honor, as Your Honor knows, who made that first $100,000 contribution to the ACLU, and he made it also to the CHLA.
Your Honor, at this point, I'm going to object. Mr. Chu has largely just read his brief and confined his arguments to those directed in the motion, but like we saw with the last motion to strike, he's now directing his arguments to something other than what's at issue here, and I would object because I think making an argument not to you but to the cameras, it's disrespectful to the court and to everyone's time, and it also threatens to undermine the integrity of this process and risk the jury being influenced by outside factors.
Well, it's his argument. I'll allow him to do his job.
Thank you.
Thank you.
Thank you, Your Honor.
All right, let's get a break in here. Benjamin Chu will continue his argument right after the break.
At SmileDirectClub.com.
Back to the court we go. Benjamin Chu delivering his motion to the judge to throw out Amber Heard's counterclaim.
As I was trying to say, what Mr. Depp is suing about are the 3 statements. And it's very clear, despite the pious opening statement that about the First Amendment, that with the testimony of Terrence Doherty and the emails that were admitted as exhibits, that the ACLU and Ms. Heard were conspiring to make it very clear that those 3 statements were related to Mr. Depp, because otherwise nobody had any interest in the article. And it's crystal clear from that. They wanted to time this thing with the release of Aquaman, which was her first film of any significance in terms of popularity, and to do that. That's very clear. So the charade that this had something to do with public policy is risible, and that is not why the anti-SLAPP protections were enacted. They were enacted to protect the rest of the article, not what Mr. Depp is suing about. As generally analyzed by the courts, a matter of public concern is one which relates to, quote, a matter of political, social, or other concern to the community, unquote, as opposed to a matter of only, quote, personal interest, unquote. That's Connick versus Myers, 461 U.S. 138 at page 146. Instead, the defamatory implication at issue in each of the 3 statements at bar relate to the personal grievances between Mr. Depp and Ms. Heard, which does not rise to the level of a matter of public concern with broader implications for society beyond the 2 litigants in this action any more than Mr. Waldman's statements. I mean, adding the gloss of public policy might immunize the statements that relate to public policy, but those are not at issue here. Mr. Depp agrees with those statements. We're talking about the 3 statements that they very intentionally and very cleverly put in to make it clear the implication that it was about Mr. Depp. They had lawyers from the ACLU working around the clock with Eric George to be as clever about this as possible. And Your Honor remembers the testimony of Mr. Doherty about the consternation at the ACLU when they realized that USA Today and everybody else who read the article knew darn well that this was about Mr. Depp. This cannot be protected by the anti-SLAPP statute. It is a cynical runaround. And I think now that we have the undisputed evidence from the ACLU in the form of the testimony of Terrence Doherty, who is not only their corporate representative, he was their general counsel. He is a brainiac lawyer. They knew exactly what they were doing, Your Honor. And he referred to testimony of a woman at the ACLU who said she had nightmares about Ms. Heard, and he expressed no concern about that. Now, that was either because they knew about that was either a reference to this game they were playing with the op-ed or the conspiracy they had to cover up her failure to make the donations. The donations became pledges, but we have evidence that she refused to sign the pledge card. So she's caught either way. Simply stated, Your Honor, Mr. Depp is not suing Ms. Heard for making statements about society in general. I think that's very clear from the record evidence. Mr. Depp is suing her for publicly naming him as an abuser by implication and forever tarnishing his good name, an act that, coming from an ex-spouse, is fundamentally personal in nature. For that reason as well, Your Honor, Virginia's anti-SLAPP statute is not applicable. And based on the foregoing, Your Honor, Mr. Depp respectfully submits that the court should grant plaintiff's motion to strike the counterclaims and also strike her claim that she is immune under the anti-SLAPP statute. Thank you very much, Your Honor.
Thank you, sir. Yes, sir.
Thank you, Your Honor. As Your Honor knows, the trial court is required to accept as true all the evidence favorable to Amber at this point, as well as any reasonable inference a jury might draw therefrom which would sustain the counterclaim. That's the correct standard here. I'll address the actual malice argument first, the agency argument. Your Honor, there's plenty of evidence in the record from which the jury could determine that Mr. Waldman was Mr. Depp's agent. He made those statements. The statements referred to him as Mr. Depp's attorney. As Your Honor ruled on Friday with respect to the jury instruction conference, an attorney is an agent of his client. Mr. Waldman testified that he's been Mr. Depp's attorney since 2016. He freely admitted speaking to the press on Mr. Depp's behalf, and he refused to answer question after question about that agency, so he can't use that as a sword now. Mr. Chu puts a lot of emphasis on the fact that Mr. Depp allegedly didn't see the comments that were made that are the subject of the counterclaim, but as Your Honor well knows, whether he saw them or not is not the standard for agency. There's also evidence that Mr. Depp met with the Daily Mail with Mr. Waldman prior to the defamatory statements being made and released. I believe that was in February of 2020, just 2 months prior. Mr. Waldman also concocted a story that Amber was being investigated for perjury by filing a perjury complaint against her with the LAPD. He disregarded any evidence that he didn't believe would fit in his narrative, that would fit in this story that he was speaking about on behalf of Mr. Depp. And after Mr. Depp lost the UK proceeding, after Mr. Depp was ruled to be a wife beater by the court in the UK proceeding, the court there found him to be a wife beater. Mr. Waldman then got an overseas tabloid to run a story claiming that Amber was being investigated for perjury, which simply wasn't true. He walked into the LAPD, filed a complaint for perjury against Ms. Heard, found a media outlet that doesn't follow the two-source rule, and then he had let the world believe that the LAPD was investigating Ms. Heard for perjury. That's a shameful and a sickening example, Your Honor, of the lengths that Mr. Depp, through his agent, Mr. Waldman, would go to smear and to defame Amber Heard, and that continued in the 3 statements in the counterclaim. Your Honor has heard evidence, I won't go through all the evidence, but Your Honor's heard evidence from Ron Schnell, who's traced the negative hashtags toward Amber Heard online associated with those defamatory statements, and noted the staggeringly high number of them that were associated with Mr. Waldman. Under the principles of the agent-principal relationship in Virginia, Your Honor, when Mr. Waldman made those statements, he was standing in the shoes of Mr. Depp. They are one and the same for the purposes of those statements. As Your Honor discussed at length on Friday, Mr. Waldman made these statements with actual malice. There's plenty of evidence from which the jury could infer that, and his own, both from the actual malice from Mr. Depp and Mr. Waldman's own reckless disregard of facts that didn't support Mr. Depp, and his attempt to manufacture false evidence that did. As Your Honor found in the hearing, I believe it was on March 24th, after Your Honor denied Mr. Depp's motion for summary judgment, Your Honor said, as to malice, a fact finder could reasonably conclude that Mr. Waldman made the statements with malice because Mr. Waldman has no personal knowledge of the party's marriage and still made the statements at issue. Nothing in this case has changed that. If anything, the evidence has only made it more clear that that is an inference that the jury can and we believe will find. So, Your Honor, there's no basis to grant a motion to strike on this agency argument, on the actual malice argument. The evidence shows that not only was Mr. Waldman, Mr. Depp's agent, but that the two of them conspired to falsely accuse Amber of creating a hoax and falsify evidence that they believed supported their theory and what they wanted to achieve. As Your Honor well knows too, I won't go through all the law, but both agency and malice can be inferred through circumstantial evidence. There's plenty of evidence in the record from which the jury could infer those. Moving on, Your Honor, to the independent contractor, the court's already rejected this argument, ruled that an attorney-client have a principal-agent relationship, and as Your Honor said on Friday, there's no evidence in this case of anything otherwise. As to the argument that the counterclaim statements are statements of opinion, the court has already found twice that they are not statements of opinion, both on January 4th, 2021, in its opinion letter denying Mr. Depp's demur as to the counterclaim statements, and at the motion for summary judgment hearing in March of this year. As the anti-SLAPP argument, the court again has already ruled at the March 24th, 2021 opinion that the statements are, as a matter of law, regarding matters of public opinion. The court has already ruled that. Therefore, the only remaining issue for anti-SLAPP is whether the intent element of immunity is met. As we discussed on Friday, the intent element of immunity is substantially the same as the actual malice standard, which the evidence in this case easily allows a jury to find in favor of Ms. Heard on that. I won't go through the litany of evidence that supports that Mr. Depp is an abuser here, but I'll touch on a few things that relate to Mr. Chu's argument. One, Mr. Chu was totally misrepresenting Mr. Doherty's testimony. There's not a single piece of evidence, Your Honor, in this case suggesting that Ms. Heard and the ACLU were somehow conspiring to achieve a defamatory implication to Mr. Depp. That's simply not what Mr. Doherty said. Mr. Chu, feel free to argue that to the jury, but that's not what his testimony reflects. Your Honor, there's also plenty of evidence that's been adduced both in Mr. Depp's claim and in Ms. Heard's counterclaim that show that absolutely that the counterclaim statements are 100% false. There was no hoax perpetrated. Mr. Depp is an abuser who abused Ms. Heard. She did not conspire with her friends to create a hoax. She did not create a hoax herself. And just very briefly, some of the evidence that's come up since the last motion to strike, Your Honor, that Mr. Chu conveniently disregards in his brief are the testimony of Rocky Pennington, the testimony of Josh Drew, the testimony of Elizabeth Mars, all of whom completely corroborate Ms. Heard's account of the events of May 21st, 2016. The testimony of Melanie Iglesias, who testified that she covered Ms. Heard's bruises with makeup right after the December 15th incident, that provided ample testimony to support that Ms. Heard often would cover her bruises that were caused by the plaintiff in this case, by Mr. Depp, with makeup. He ignores the evidence of Christy Sexton. He ignores the evidence of Io Tillett Wright. He ignores the evidence of Whitney Enriquez. All of these witnesses and others have testified extensively about Mr. Depp's abusive behavior toward Ms. Heard. Physical abuse, emotional abuse, psychological abuse, verbal abuse, Your Honor. Mr. Depp's own writings, recordings, pictures, and videos confirm that. The list goes on. There's abundant evidence in the record, Your Honor, from which the jury could, and again, we believe will find that Ms. Heard is not liable for defamation to Mr. Depp, and therefore, by definition, she has not acted with actual malice, and based on the court's rulings on March 24th, 2021, she would be entitled to anti-SLAPP immunity, which would permit her to ask the court to award attorney's fees against Mr. Depp. So with that, Your Honor, I'm happy to answer any questions the court has.
That's
but
fine.
that
Thank you,
covers
sir.
it. Thank you.
Yes, sir.
All right, there's Ben Ruttenborn. He's saying no. There's more than enough here to move forward. Let's get a break in here and see if Benjamin Chu has something to say as a rebuttal, and then we'll get the judge's ruling. We're back. Both sides have argued this motion from Johnny Depp's team to throw out Amber Heard's counterclaim after they rested. If you just joined us, the Amber Heard's team has rested their case in chief. Let's see what the judge decides.
All right, in this matter, I've reviewed all the defendant's evidence as to her counterclaim, and I've considered the arguments of her counsel and plaintiff's counsel. First, to address a few issues that I believe are outside the motion to strike, and that's as to the SLAPP defense. The SLAPP defense is just that, it's a defense, so it's really not considered in a motion to strike. Having said that, we went down that legal road on Friday as far as the SLAPP defense goes, as far as the jury instructions. In this particular case, if the plaintiff prevails, it must be with actual malice. Therefore, if it's with actual malice, immunity does not apply under that statute. So we will deal with that with jury instructions, and we have. As to independent contractor, again, I think it's outside the motion to strike. However, Mr. Waldman was plaintiff's attorney since 2016. Before the initiation of litigation, there is evidence that Mr. Waldman had a certain role during the prior divorce proceedings in the UK case. Additionally, there is evidence that shows his legal representation was broader than just a limited litigation, as outlined in all the cases presenting an attorney as an independent contractor. So the only evidence in this case to this point is that Mr. Waldman was an agent to Mr. Depp, and that is the basis to weigh the motion to strike. As far as the opinions argument, again, I think that is outside the motion to strike. The opinions argument, the court has already ruled on this matter as to the 3 statements that are at issue in the counterclaim, ruled that they were not opinion at the demur and at summary judgment. So that argument will not be part of the motion to strike. So when assessing a motion to strike, the court accepts the favorable evidence adduced as true towards the non-moving party. The court cannot reject any inference from the evidence favorable to the non-moving party unless it would defy logic and common sense. When there is any doubt and question, the court should overrule a motion to strike. Agency may be inferred from the conduct of the parties and from surrounding facts and circumstances. When there is no direct evidence, circumstances may, and usually are, relied upon to determine whether an agency relationship exists. A principal is liable for the tortious acts of his agent if the agent was performing his principal's business and acting within the scope of his agency. If an agent's tortious act arises from their agency relationship is enacted in part to service the principal can be held liable for the tort. Here, the alleged tort is defamation. Besides demonstrating the agency relationship, the defendant must prove Mr. Waldman published an actionable statement, meaning a statement that is both false and defamatory, with the requisite intent. As to agency, Mr. Waldman was plaintiff's attorney at the time of the alleged defamatory statements were made. Mr. Waldman does not deny this, and neither does the plaintiff. Moreover, Mr. Waldman made the allegedly defamatory statements about the defendant during the proceedings of this action and interacted with the defendant once the statements were made while still representing the plaintiff. Taking the surrounding circumstances as a whole, an agency relationship can be inferred, and thus a scintilla of evidence regarding agency must be turned over to the jury. In addition, the jury may infer that Mr. Waldman made these specific statements to a third party to serve as plaintiff by portraying defendant as an opposing litigant in a negative light. It is not disputed that Mr. Waldman published statements and that there is a question as to whether statements are false, and both parties disagree and have presented conflicting evidence as such. As to actual malice, Mr. Waldman made the counterclaim statements after he met with his client. In addition, there is evidence the plaintiff was with Mr. Waldman at a meeting in February 2020 with the Daily Mail online. Further, defendant claimed that she met with Mr. Waldman where he threw the paper containing the counterclaim statements within them. Consequently, there is more than a scintilla of evidence that a reasonable juror may infer Mr. Waldman made the counterclaim statements while realizing they were false or with a reckless disregard for their truth. It is not my role to measure the veracity or weight of the evidence. The Fourth Circuit and the Virginia Supreme Court have made it crystal clear that actual malice is a question for the fact finder. So therefore, the plaintiff's motion to strike is denied. Okay? Thank you. Is there any other preliminary matters before the jury?
Yes, Your Honor. We approach.
Okay.
All right, there's the judge's ruling denied. That's expected. It's usually a home run. It's a grand slam if you can get a judge to throw out a claim mid-trial after one of the parties has finished his case, but obviously putting it on the record.